You bought the land because you believed in quiet, not the empty kind, but the kind that hums like a low river through tall pines. The kind that heals. 47 acres of untouched soil just past the old county line of Redwood County, where the road stops being asphalt and starts whispering gravel. It wasn't flashy land. No lake, no mountain view, no cell reception unless the wind leaned your way. But it was yours, paid in full, signed and filed, tucked in a dusty manila folder in the back of a metal cabinet. You weren't rich. You weren't the kind of person people write about. You were just tired, retired military, one divorce behind you, a daughter who calls once a month from across the country. You bought the land to build your last home, a small cabin with a sunrise porch and no neighbors within shouting distance. You didn't even know about the HOA when you bought it. The agent never mentioned it. The sign said unincorporated community, and that was good enough. You closed with a handshake and a notary just before the market jumped again. For a few years, nothing happened. You drove out on weekends, camped under stars, brought in gravel, cleared brush by hand. Slow, steady work. You kept the floor plan taped to your fridge in town, pencil marks needle sharp along every line. Then one spring, 5 years in, a white envelope appeared taped to your gate. Heavy paper with a gold seal and a return address you didn't recognize. You peeled it off, thinking contractor junk mail. Inside was a notice of noncompliance property aesthetic standards. It claimed your lot violated landscaping rules, cited visual obstructions, and demanded $50. You blinked. There was no lawn, no fence, no landscaping, just trees, dirt, and a sun-faded orange tarp over tools. How could natural terrain be out of compliance? You shrugged. Mistake probably, and tossed it in the truck. 2 weeks later, another notice came. Then another. They started arriving certified, then by email. Calls followed from something labeled HOA Enforcement Committee. Fines jumped, $150, $200. $1 letter claimed you owed $3,250 in arrears. Another gave 30 days to remediate noncompliant terrain and visual debris. One included photos. Someone had walked onto your land, uninvited, and shot your half-dug septic trench and a neat stack of lumber. You drove out and found fresh tire tracks in the clearing. You checked your deed. The county confirmed your land sat inside Pine Hollow Development District 3, but your parcel had been grandfathered before the HOA formed. That sounded safe, so you relaxed, but the letters didn't stop. The language sharpened. Violation 3(1)(b), failure to maintain visual uniformity. Section 421, non-permitted ground cover. Section 8.5, refusal to comply with board instructions. You weren't just being fined. They wanted to dictate when to build, where to dig, what the land should look like. You considered calling a lawyer, but part of you believed it would blow over. How could an HOA fine a parcel with no residents, no utilities, no mailbox? It was just dirt, trees, and a plan. Then a courier delivered a glossy, heavy envelope. Inside, a stamped spreadsheet and a bold notice. Lien filing process will initiate within 30 calendar days unless balance of $48,390 is received in full. Your stomach dropped. $48,000 more than you paid for the land. Line items stacked. Monthly penalties, interest, administrative processing, legal consulting search, non-response surcharge. This wasn't annoyance. It was a grab. That land was your peace, your legacy. You buried your dog there. You carved your daughter's initials in an oak. You sweated over every rock you moved. You weren't surrendering because someone behind a desk didn't like the way your brush pile looked on satellite. You sat down, pulled the old folder from the cabinet, and started to fight. The next urgent escalation arrived on a Tuesday while you were stacking timbers. $975, citing 3 ignored violations. It wasn't embarrassment you felt, it was insult. You pay taxes. You return calls. You're old school, a ledger guy. But they talk to you like a slacker dodging parking tickets. That night you lined every letter on the kitchen table, 7 of them by then, and annotated them in red ink. The citations were inconsistent. visual disturbance, non-standard materials, prohibited excavation. You hadn't even poured a foundation. You called the listed number voicemail. You emailed the compliance officer bounce. So you drove to the HOA office, a prefab trailer between two model homes, more sales floor than public office. A teenage receptionist in a polo asked if you had an appointment. "I have 30 envelopes and a headache," you said. She disappeared. Out came a mid-40s man in khakis and a golf shirt, the kind of confident small man a title can make. His tag read Bradley Cole, HOA president. "Let me guess," he said without a handshake. "Parcel 47. You frowned. "Excuse me." "You're the brush pile guy," he chuckled. "No offense, but the community's got to look right. We're keeping things harmonious. My place is a quarter-mile from the nearest neighbor. Still part of the HOA, every parcel counts. You agreed to terms at purchase." "No," you said evenly. "I didn't. I bought 5 years before your HOA existed. There was no agreement." His smile flickered. "That's a gray area. Our lawyers interpret it differently." "Then I'd like to speak to your lawyer." He laughed. "That's not how this works." "How does it work?" "You pay the fines, keep it to standard, we move on. Or you don't and we proceed with lien processing. Not personal." You felt your fists ball. He spoke like he already knew the ending, as if you were a line item on a spreadsheet. You left without another word. The letters accelerated. Fines came like clockwork. $250, $600, $200. They weren't waiting for you. They were building a paper case. One envelope carried a pre-lien advisory, warning that persistent violations could result in remedies including forced sale to recoup unpaid dues. That's when it clicked. This wasn't incompetence. It was a strategy. They didn't want compliance. They wanted your land. Maybe a developer had eyes on it. Maybe it was power. But they had a quiet chokehold, and they figured you'd be too worn down to fight. They didn't know your father was a lawyer, a meticulous one who taught you to read contracts before you could drive. Every visit, you brought a banker's box, deed, plats, county maps, zoning, and every HOA letter. You spread everything again, this time hunting not for what they said, but what they didn't. They claimed jurisdiction, but your deed never mentioned them. Your parcel predated the community's name. Something was missing, something they hoped you'd never find. You dug into the original purchase file, the county plats. You even called the notary who'd closed your deal. She was 82 and still sharp. "Oh yes," she said, "that big wooded lot with no water hookup." Unique, she called it. That word nagged you. She mailed a file copy of the easement she'd kept. It arrived brittle and coffee-stained, folded 4 ways. There it was, buried in legalese near the bottom. A clause. You held the page like a relic, fragile but heavy with consequence. "This parcel, having been subdivided and recorded prior to the establishment of any community association, shall not be subject to any subsequently formed homeowners association, nor bound by future encumbrances unless expressly agreed by the owner in writing." 1 sentence, 1 silver bullet. You didn't feel triumph yet, just steadiness, like something inside you that had been unraveling finally knotted again. They'd overstepped clearly, provably. You hadn't agreed to anything. You photographed the page, made 5 copies, put 2 in a fireproof box, 1 in the glove compartment, the original back in the folder that now felt like a sword. But paper alone wouldn't make Bradley Cole fold. People like him don't retreat, they bluff harder. You waited for his next move. 3 days later, a UPS driver left a glossy black envelope sealed with a silver crest. Inside, notice of intent to foreclose on lien. Total due, $48,390.76. Fines, interest, enforcement, non-cooperative penalties. They claimed your land was legally encumbered and headed to auction in 60 days. Attached was their ledger, a fiction of visual nuisance, landscape irregularity, drainage obstruction, in-person compliance surcharge. They made one fatal error. They cited a bylaw dated March 1996. Your clause was October 1987. Precedence. You called an old family friend, Monica Reyes, your father's paralegal for 2 decades, sharp as ever, semi-retired in Arizona. You scanned the clause. She called back in 15 minutes. Whoever's pushing that lien is playing with fire, she said. She asked pointed questions about dates and the HOA's origin. Do you have your dad's old Rolodex? You did. She told you to look under H. Harold Benton, Esquire, retired real estate attorney, County Land Authority. Call him, Monica said. He drafted that exemption language back then. If it's what I think, your parcel isn't just exempt, it's firewalled. What they're doing is real law illegal, not HOA pretend law. Harold Benton remembered immediately. We wrote that clause for 2 lots, he said, voice papery but amused. A buyer insisted on no community restrictions. Was that buyer my father, you asked? No, he said, chuckling, but it could have been. He gave you the words you needed: quiet title action and declaratory judgment. If they tried to auction before the judgment, fraud. Want me to make a call? He asked. No, you said. I want them to say it out loud. You didn't storm the office. You walked, slow, deliberate, like a man with time and nothing left to lose. You wore your faded army field jacket because it fit and had pockets big enough for every paper that mattered. Monica Reyes flew in despite your protests, hardshell folder in hand, eyes bright with that contained legal fire you hadn't seen since your father's funeral. Same prefab office, same plastic plant, new receptionist, headphones off the moment Monica slid a gold-edged card across the desk. We need Bradley Cole. We're here regarding a fraudulent foreclosure. The receptionist swallowed and phoned the back. Bradley appeared, same khakis and smirk. The smirk slipped when he saw Monica. You placed the 1987 clause on the counter. He didn't touch it, but his eyes flashed recognition, long enough to tell you he knew. Monica spoke evenly. By recorded easement and county law, my client's property has never been subject to your association, unless you can produce an amendment signed by my client consenting to HOA governance. There isn't one. Your lien is void. Every fine is unlawful. Your foreclosure notice is fraudulent. She opened her folder and slid 3 stapled packets. Intent to file civil action, fraudulent lien, harassment, attempted unlawful seizure. The smirk cracked. You knew I wasn't part of this HOA, you said. From the beginning, you thought I'd fold. He didn't answer. If this isn't resolved in 72 hours, Monica said, we file in Superior Court. We will also notify the county clerk, State Real Estate Board, and the Attorney General. Bradley lifted a hand. Let's not be rash. I've watched you weaponize policy to intimidate a man off his legally owned land, Monica said. If you think this is rash, wait for depositions. He looked at you then, not with condescension but with dawning horror. I can bring this to the board, he said. There may be a resolution. You'll have our final offer in writing, Monica replied, turning for the door. You folded the clause into your jacket. I spent years fighting people like you said quietly. The uniform's gone, the habit is. Sun hit your face outside. In the truck, Monica grinned. I missed this. I didn't, you said, looking toward your ridge, but I'm glad I remembered how. You slept lightly, not from fear but because your mind clicked back into mission mode. Monica called it building the bunker, legal defense. You took it literally. By dawn you had every old file on the bench. Discharge papers, insurance, medical forms, real estate records, plat maps, water rights, escrow. Dust and ink, clues hidden in brittle envelopes. Contract, simple carbon copy, no HOA language, only taxes and zoning. Plat map with your parcel 47A bolded. A tiny asterisk on the corner led to a footnote. Easement agreement, Oct. 1987, book 214, page 342. Geography plus law check. Next, you built a timeline on the pegboard. Blue for your documents, red for HOA letters, green for public records, yellow for key quotes. It looked like a TV detective board because in a way that's what it was. Patterns emerged. District 3 didn't exist until 2013. Your purchase was 2006. Bylaws they cited were amended right before new fines hit. You found a paragraph in one filing about future integration of fringe lots into HOA assessments. Fringe lots, bureaucratic camouflage for parcels like yours. You filed records requests with the clerk. Days later, you sifted through a digital mountain and found a memo from Bradley Cole recommending consolidation of visual standards and administrative control over orphan parcels. Orphan parcels, they'd named you like an afterthought. You printed it, highlighted the sentence, pinned it to the center. The blur resolved. Bradley was executing a plan. You were a test case, proof of concept for a paperwork seizure machine. Monica reviewed your timeline and nearly laughed. Better than I hoped, she said. Modified bylaws, backdated assessments, selective enforcement. That's targeted harassment and breach of fiduciary duty. Fiduciary duty, you asked. HOA boards aren't monarchs. She said, they're obligated to act for the community, not themselves. If Bradley pushed this to help a developer or himself, he's liable. You printed the clause in bold on legal paper, then in 18-point. You embedded it in a cover letter and had it notarized twice. Monica teased you. You're not building a case, you're building a doctrine. She wasn't wrong. You were preparing for war fought with filings, not fists. You gathered witnesses. Earl Mallon, the brush-clearing contractor from 2007, remembered a developer rep saying, "That parcel outside our control." He signed a declaration. Monica turned it into an affidavit. Clara Young, 2 lots over, had had similar fines dropped when she pushed back proof of selective enforcement. Monica said, "It's time." You delivered the packet in person, time-stamped your copy, and on instinct, drove straight to the county recorder. In a stack of resolutions, you found 22B, an amendment to bring non-residential lots into coverage zones. The fine print read, "Properties identified as historically unencumbered may be assumed compliant if no written objection is submitted within 12 months of notice." Assumed compliant, silence equals consent. That was their trick. Generic letters, no contracts, then paperwork claiming you agreed by not disagreeing. You printed it, highlighted it, dropped it into a folder titled Motive. Monica nearly shouted on Zoom. "Constructive fraud," she said. "Let's make them explain that to a judge." You stood on your land that evening as wind combed the pines. The soil felt different, like ground retaken. Monica handed you a pen camera. "Public meeting, public record," she said, razor smiling. "Let's get them on tape." The HOA board met in a back room that smelled like burnt coffee, folding chairs, fluorescents, half a dozen residents. The projected agenda showed general enforcement review and external counsel engagement. Bradley sat with a gavel and 3 uneasy board members. He spotted you and stiffened. "Meeting to order," he announced. "First item, correspondence from Parcel 47A." He glanced at you. "We received materials asserting legal exemption. We maintain jurisdiction under Resolution 22B, passed in 2019. You raised your hand. "This isn't public comment," Bradley snapped. "Clarification," you said calmly. "Under what legal authority does 22B retroactively apply to parcels excluded from the original charter?" He blinked. A board member whispered to him. "We're not debating legal minutiae," he said. You held up the clause. "This isn't minutiae. It's a recorded easement from 1987 expressly excluding my land unless I sign. I haven't." A woman gasped. A board member asked, "Do we have that on file?" "I submitted it 2 days ago," you said, time-stamped, along with notice of intent for declaratory judgment. Murmurs rose. Bradley hammered the gavel. You stepped forward, not threatening, just steady. I'd like to know why the lien notice lists fine amounts not approved in any posted budget, you said, and why your ledger bills legal consults before any challenge, and why a memo under your name recommends acquiring fringe lots through silence-based compliance. Bradley shot up. This meeting is over. No, a woman in row 2 said. I want to hear this. What memo? A man asked. You turned to them. A document recommending that parcels like mine be assumed compliant if owners don't object in writing. That's not consent, that's coercion by omission. This is harassment, Bradley barked. We'll file a cease and desist. You already did, you said, holding up yesterday's letter. You also doubled my lien to $51,000. I've forwarded both to the Attorney General. Silence. Then the nervous board member cleared his throat. I move we pause enforcement and seek independent legal review. Hands rose, motion carried, cracks in the wall, not by shouting but by paper and truth. Outside, Monica grinned at your truck. Better than expected. They're cornered. Be ready, cornered rats bite. You filed the lawsuit on a quiet Wednesday. No press, just a clerk stamping a stack 70 pages thick. Exhibits, affidavits, timelines. Claims, declaratory relief affirm the exemption, fraudulent lien knowingly filed without authority, intentional infliction, intimidation on letterhead, and breach of fiduciary duty against Bradley Cole and the board. Monica tapped the last claim. This is where their personal insurance gets nervous. Service went out next morning. A neighbor texted a photo of Bradley on his porch, pale, phone in one hand, papers in the other. The HOA fell quiet, then pushed a press release about mischaracterized procedures. They hired a big outside firm, filed a motion to dismiss. Monica shredded it in reply. The court set a preliminary injunction hearing in 3 weeks. They used the time. Your brush piles were suddenly fire hazards. A drone buzzed your trees. Someone called animal control about pests. You installed trail cams, filed FOIA for drone logs, hired a surveyor to stake neon orange flags every 10 feet along your boundary. A week before the hearing, a hand-delivered settlement arrived. 10 pages offering to release the lien, drop fines, and issue a clarification of jurisdictional ambiguity if you promise not to sue or publicize. You handed it to Monica. She glanced once and let it slide into your trash. They don't regret, they're afraid, she said. Let's finish this. The hearing day was rain-washed. You wore your best shirt, boots polished, papers in order. Monica's hair was pulled back, her face calm. Bradley sat in the back row, no gavel, no grin. The judge was direct. Monica presented the clause, the dates, the escalation pattern, each page locking into place. The HOA's lawyer mumbled about administrative confusion and good faith error. If this were a mistake, Monica said, they would have stopped when shown evidence. Instead, they escalated and threatened foreclosure on a parcel outside their authority for the crime of saying no. And silence is not consent. The judge leaned forward. On the deed, the easement, and the sequence of notices, I grant the preliminary injunction. The HOA is prohibited from issuing further fines, enforcing any lien, or taking action on Parcel 47A pending trial. Gavel, breath released. It took 4 months to reach trial. They stalled, filed continuances, argued jurisdiction. You didn't budge. You've stood down mortars and midnight loneliness. You can stand this. Discovery unearthed the rot, internal emails targeting your parcel. One from Bradley Reed, if we pressure him hard enough he'll pay or sell. East Ridge is perfect for the trail expansion. Another forwarded your survey with he's sitting on the last unregulated stretch. Let's fix that. And there it was. Fringe Parcel Acquisition Strategy, drafted by Bradley Cole, a playbook for identifying, pressuring, and absorbing independent parcels through cumulative fines, liens, and non-responsive flags. We're not just going to win, Monica said, reading it a third time. We're going to scorch the earth. The courtroom was modest. No cameras, just a judge, a 7-person jury, and 2 rows of residents, arms crossed. The HOA's lawyers spoke in polished phrases: misunderstanding, charter compliance, vague exemption. Monica didn't pace or shout. She lifted your deed. This man bought his land free and clear. A recorded easement explicitly exempts him from HOA authority. Yet for a year he was fined, surveilled, threatened, and nearly stripped of his home, not by mistake, but because a board saw something it wanted and assumed he wouldn't fight. Then she read the fringe parcel strategy aloud. The jury leaned forward, the judge's eyebrow climbed, Bradley seemed to shrink. Witnesses followed. Earl Mallon confirmed a developer staffer admitted your parcel was outside control. Clara Young described selective enforcement dropped when challenged. Then a surprise: a former HOA secretary who'd resigned. She testified Bradley ordered internal maps altered to make your lot appear inside HOA bounds. The defense called her disgruntled. They blamed clerical error, everything but the truth. On the final day, Monica asked you one question on the stand: why did you fight? Because they thought I didn't matter, you said. They assumed no one would care about one man on one piece of land. But land is more than dirt. It's dignity. I wasn't letting them bury mine under paperwork. The jury took less than 2 hours, unanimous in your favor. The court declared the lien fraudulent and ordered it removed immediately, issued a cease and desist against the HOA from contacting you, and referred the case to the Attorney General. Punitive damages covered fees, with enough left to build your porch and hang a wind chime. As you stepped outside, Bradley didn't look at you. He stared past, a man who tried to erase someone and failed. The sky wasn't cinematic, just honest blue. What now? You asked Monica. Now you go home, she said, and put up a sign. What kind? The kind that says what the law already does. You didn't post it that day. You sat on your new porch first, coffee in hand, birds loud in the eaves, mailbox finally quiet. No envelopes, no drones, no strangers with clipboards measuring brush height, just wind, trees, and time, the good kind. Word spread, quiet knocks, emails, notes tucked under your wiper. Some came from folks who once trusted the board and realized what nearly happened to you had already happened to others. Fines they'd paid because they didn't know the magic sentence existed. You became proof that no could be a full defense when the law was on your side. Clara Young brought warm lemon bread one afternoon and took a seat on your porch swing. The board had called a vote. Bradley Cole stepped down. Others would follow. The memo leaked. Your fight became a warning. That evening you dug a post hole deeper than necessary, because it mattered. You set a slab of black walnut and painted the letters with slow care. Private property, not under HOA jurisdiction. Trespass at your own risk. Underneath, smaller: know your rights, protect your peace. You didn't add your name. You didn't need to. The next morning you walked the perimeter. The trails felt clearer. Sunlight came down at a kinder angle. You paused at the ridge where the ground dips toward the old creek bed and remembered day one, boots sinking, plans big. You'd been alone then. You weren't alone now. You had something else, not just land, but a story. And told truthfully, stories outlast fences, gavels, and bylaws. You went inside, pulled a yellow pad, and wrote the first line. They tried to seize my land through HOA fines, but I found a hidden clause that saved everything. You set down the pen and listened to the wind scroll through pines like pages turning. This time the silence wasn't surrender. It was victory, clear, lawful, final.